GDPR, everyone's favorite acronym, came into force, data protection compliance continues to be seen as a high priority issue, which is good, rightly so. As everyone here will know, it's of particular relevance in the context of online business activities, where personal data is being collected via a website. So I thought I'd quickly personal data broadly means any information about any information which an individual can be identified, and that will include, importantly in this context, an online identifier like an IP address. Worth noting also, data with anonymous in a strict sense, so it can't be re-engineered to form data or be caught by the GDPR rules. So yeah, the default position really is, if a website operator collects personal data, then they will normally be classified as what's known as a data controller, and must therefore provide relevant data subjects with transparent information, normally in the form of a privacy policy. And that will cover how it collects that data, what it uses the data for, on what legal basis it processes that data. Just there are a number of legal bases which can be relied upon to process personal data. The key ones being consent, obviously, or if the processing of that data is necessary for the performance of a contract with that data subject, and also where the processing is required for the legitimate interests of the business. It's still a common misconception that consent is the safest option when it comes to having a legal basis to process data. Consent is not actually as robust as you might think. Under GDPR rules, a data subject must be able to withdraw their consent as easily as they gave it. So it's not actually as robust as you might think. So it's important to think through those legal bases carefully. Also, that privacy policy will need to tell data subjects about who their data is being shared with as well. Again, similar to the information requirements, a lot of website operators make the mistake of simply uploading a template privacy policy to their site and without adapting it, hoping that taking a catch-all approach, saying your data might be shared with this third party, or we might use it for these purposes, hoping that will make them compliant. Sadly, it's not that simple. The privacy policy needs to be specific. So the business in question does need to sit down, analyze their data flows, analyze where that data is going, and draft the privacy policy such that the individual has specific information about what's happening to their data. Now, this is probably a good moment to, well, I guess in the context of data privacy, one hot topic at the moment is the California Consumer Privacy Act and how that compares to and interacts with the GDPR. And I will hand over, if Kelsey can hear me, and also if I can hear her, hand over to Kelsey for this bit.
Yeah, I can certainly hear you, Alistair. I assume you can hear me.
Yes, I can.
Yep. Okay, so just very briefly at the outset, it's kind of important to remember that the United States does not have a single privacy law as such. Unlike the European Union and indeed the United Kingdom, the US doesn't really understand the concept of privacy. It's not mentioned in our Constitution at all. So it's really down to the states, so each of the individual 50 states, to make up their own privacy laws. Now, of course, there are some federal laws, so nationwide laws, that concern privacy of health data and of children, but these are very specific situations. For everything else, for the personal data that we all know and recognize as such, so names, addresses, and things of that nature, it falls down to the states. So you might be wondering, why California? Well, California is, well, if it was its own country, it would be the 7th wealthiest country in the world. It is massive. There are people who live there. And importantly, there are a lot of tech companies that are headquartered there. Accordingly, the California legislature, giving into pressure by consumers on one hand, wanted more privacy protections, as well as tech companies who kind of wanted to preempt a very strict rule, lobbied the government to come up with the California Consumer Privacy Act. As Alistair has put here on the slides, it does provide some GDPR-esque protections, but there are important differences to be aware of. For our purposes, the the CCPA only really applies to companies that are really big. We're talking revenues of 25 million or more each year, and collect or otherwise use data relating to more than 50,000 Californian residents. Residents is the key term here. If you are a New York person living in New York, the CCPA may not apply to you specifically. It might apply to the company, i.e. Facebook, that's based in California, but you yourself as a non-Californian resident will not have any rights to that. As we mentioned, a lot of tech companies, a lot of website hosts and so on are based in California. And even those that are not, for example, Microsoft, they are trying to kind of adhere to the CCPA because they anticipate, and I believe rightly so, that this is going to be the general trend moving forwards. So yeah, the key important thing to remember is the CCPA aims to prevent companies from unlawfully selling consumer data for the purposes of those cold calls and annoying telemarketer calls that we used to get a lot of here, less so because of legislation, but are still a huge problem in the States. So Alistair, I think that basically summarizes it, unless you had any specific questions.
No, that's perfect. Thanks very much, Kelsey. So yeah, a connected issue then, moving on from kind of strictly data protection stuff, is obviously cookies. It's another crucial issue for most website operators. Hopefully everyone will know what we mean by cookies. So I won't kind of go into that in detail. The main legislation in this area is the Privacy and Electronic Communications Regulations. That's a bit of a mouthful, so us lawyers call it PECA. Cookies is an area that can cause some confusion, partly because of overlapping legislation and guidance notes, and also because it's very fact sensitive, and the legislation is quite broad because it applies to not only cookies but also what are termed similar technologies, which I'll come on to in a moment. So to cover some of the basics, I've got some kind of pointers on the slide, but the default rule really is that cookies cannot be used or cannot be placed on a user's equipment unless that user has, firstly, been given clear and comprehensive information about which cookie is being stored and kind of the purposes for why it's being stored, and secondly, that user has given their consent to that. So worth noting as well that those requirements also apply to third-party cookies. For example, ad networks placing cookies on user equipment via your site. There are, as you'll see there on the slide, very narrow exceptions to that rule. Consent is not required when the cookie meets these two exceptions. So the first one is called the communication exception, using the language from PECA, which again is quite a mouthful. That's when the cookie is planted for the sole purpose of carrying out the transmission of a communication over an electronic communications network. I'll let someone else explain what that means, because that's nice clear drafting from whoever drafted PECA.
Seems very broad to me, that term, I have to
say. Exactly, yeah. The second one, which is slightly clearer, is called the strictly necessary exception. So that's where the cookie is strictly necessary, or sometimes you would see the word essential there, for the provision of an information service requested by the subscriber or the user. So worth saying then, the first one, so the communication exception, for that to apply, the transmission of communication must be impossible without the use of that cookie. For the strictly necessary exception to apply, the use of the cookie must be essential for the service being provided, rather than important or preferable for the website operator. So things like analytics cookies won't be considered essential or strictly necessary. They're in the eyes of the regulator, that's a nice to have. on the other hand, a shopping basket functionality where the website remembers the products that a user has selected, that is normally seen as strictly necessary. But again, I would say that the circumstances caught by those exceptions are very narrow. So you're normally looking at complying with that default position, providing the information and obtaining consent. So on that, how do we provide information about cookies? Website operators do struggle with this, primarily with determining what level of detail to provide and also in what format. Helpfully, the law doesn't define what clear and comprehensive means. However, helpfully, we now do know that the information must be provided in accordance with GDPR transparency requirements. So they've actually looked at the GDPR and thought, that's a nice high standard, let's use that. So the information has to be provided in a concise, transparent, intelligible and easily accessible form in plain language. I suppose the general rule is you have to make an effort to bring the information to the user's attention before the cookie is set. And it has to be done in an appropriate way. So, for example, if you've got a very technical, platform or website, and you've got lots of different cookies and similar technologies doing lots of clever things, don't think that just presenting the user with a massive table of those will be compliant. Most users won't understand that. So what may be better in those circumstances is something shorter form, paraphrased, with a link to something a bit more detailed, which a user can look at, if they're minded to do that. So the moral of the story is it needs to be appropriate for the information being presented. There's lots of information on this area on the ICO, the Information Commissioner's Office website, and I think I've done a link there to that guidance on the slide, so feel free to have a look at that. How to obtain consent, again, in a similar way to the rules around info, you've got to comply with GDPR standards in the context of consent. And I think I've included the definition of consent there on the slide. So it needs to be freely given. The consent needs to be freely given, specific, informed, and unambiguous. And probably the most important point to note here is it must be through an affirmative action on the part of the user before the cookie is set. So in practice, what does that mean? A pre-ticked box won't cut it, and a pre-enabled cookie which isn't strictly necessary won't be compliant. The user needs to be in complete control. So some specific scenarios that we often get asked about in relation to obtaining consent for the use of cookies, browser settings. Just because the browser someone is using allows cookies by default, and often they will these days, that will not constitute valid consent. In reality, Joe Blogs will not realize that their online activity is being tracked by default. So you need to make it clear to that user what the settings are at that point. It needs to be clear that the user's been prompted to consider, their current browser settings, and that they've indicated that they're happy with that, or that they've made the decision to change those settings. Another thing we get asked about, can I obtain consent by including a line in my website T's and C's? The answer to that is no. Again, the cookie mechanics need to be separate and distinct. And again, I'll go back to what I said. It needs to be an affirmative action. It can't be kind of hidden in a set of T's and C's, and you're relying on sort of implied consent. That won't work. And finally, and this is probably one lots of people have come across, I certainly see it on a day-to-day basis, is the use of what we call cookie walls. So that pops up with a take it or leave it screen, which basically says, please accept cookies in order to continue to use this site. That's obviously not freely given consent. The user has not had a choice there, so that is unlikely to be compliant. So again, I said at the start, these rules will apply to cookies, but also similar technologies. So again, very broad, but it's basically anything carrying out a similar function. to a cookie, so fingerprinting techniques and things like that, very fact specific. So it's important to get quite granular to make sure that you've captured everything by the information, in the information that you're providing. While we're on the topic of cookies, again, I should mention that we've just released a paper on, I guess, an apparent, what you'd call maybe an apparent shift in the world of advertising tech in the context of targeted advertising and potentially an increase in the use of the less intrusive contextual advertising. So I think I've put a link to that article there on the slide. Please do have a read. That was my colleague Wana in our team. She wrote that, and it's quite an interesting one about a potential move in that space.
Okay.
So that's cookies. Just to wrap up, then, I thought, as I said at the start, it's important. It's impossible to cover in one webinar every single legal issue that you're going to face in the context of the internet, obviously. Though hopefully what I've covered so far gives you a kind of a good starting point. I wanted just to finish off, just to flag some specific high risk scenarios where you ought to be particularly mindful of potential legal implications. So is your website aimed at minors, or are you going to have any interaction with minors? If the answer is yes, then you're very likely to have additional hoops to jump through, particularly where you're collecting personal data about children. Processing of personal data, I should mention, relating to children cannot be done without consent from a legal guardian. So that's a real important one to be across if your site could be accessed by children. That, again, there's lots of useful guidance on that on the ICO website, so I recommend having a look if that's relevant to you. Linking and framing. So do you propose to link to third-party websites via your site, or frame third-party website content on your own site? Sounds obvious, but if you're going to do that, you need permission to do that. Lots of websites these days actually grant a general permission via their terms of service for other sites to do that within certain parameters, but it's important to check that. Kind of on the flip side, are you comfortable with third parties doing that in the respect of your site? And again, that's where your terms and policies will come into play and will be important. A couple more, if you're providing access to a SaaS platform or software tools, then there are likely to be additional license terms that you'll need to integrate, normally done via what we call a click wrap license. Two more, user content. So if your site allows users to post content on the site, then there's obvious points to consider there around potential liability arising from harmful posts. So that's the sort of thing that will be covered by what I talked about earlier in the on this acceptable use policy. So that will deal with content rules and standards and liability arising from that. And finally, live content. So if you're providing any sort of stream to live content via the site, then obviously you need permission from the copyright holders to do that, to avoid infringing copyright. So yes, quickly wrapping up, as I've already said, this is a broad area, obviously, when it comes to legal issues. Hopefully what I've covered today gives you an initial steer on the key points that you need to be aware of. The internet obviously isn't new, but the rules and regulations around what website operators can and can't do are constantly changing. So it's important to be alive to those issues. And yeah, thank you very much for listening. Hopefully everyone's been able to hear me and see the slides, and the sound quality is okay. But I think now I'll hand back to Joel, and we're going to do a Q&A if there's any questions.
Yeah, we had a couple of questions. Maybe if you can stop sharing now, we can get the
I'll
video
do that.
back on or something like that. Yeah, we had a couple of sound issues then, but I think it was fine. Technology always decides to sort of play up, as I'm sure you can imagine. Let's have a look. Yeah, that was.
So I think that stopped.
Yeah,
great.
You might appear back in. Have a little look here. Yeah, that was really fascinating, man. Yeah, I think you covered all the bases here, and I thought you did very well as well, given that we had a few technical issues as well. That's
Thank you.
always a bit of a challenge, that. I did laugh a little bit when you were talking about making it readable in terms of the cookie policies and stuff like that, because I have to say, most of the times when I look at it, it's pretty impenetrable, the language that's used. I mean, maybe that's a factor of people using templates and stuff like that, but a lot of the time it isn't very approachable, the language, I think.
Yeah, I mean, the ICO isn't. I said that there's lots of guidance out there on this issue. The ICO guidance itself is quite impenetrable. Sadly, they do their best. What I will say is, if you're kind of setting up a site and you're using cookies, think of how you can do it in the most user-friendly way. So normally that's done by doing it in a layered format. That's what the ICO call it, a layered format. So that's having an initial banner with a link to something a little bit more detailed, and then maybe a link to something even more detailed. So that, the information is there if someone wants to read it. But the important thing is that you make an attempt to bring that information to the user's attention, really.
Okay, that makes sense. So we had one question about companies who aren't based in the EU and GDPR. So say you've got an American company and some of your
Yeah,
audience are global. You've got some
yeah.
audience in the UK. How do you handle the different GDPR requirements then in terms of cookies, say?
So who wants Kelsey, do you want to deal with that, or I can deal with
Yeah,
that?
I can, sure. So you might remember that I said earlier that with the with California's Act,
Yeah,
they really care about where the person is located, and indeed where the company is located too. So you need to be headquartered or based in California, for the most part. The GDPR doesn't really care where the company is. It looks to, because its goal is to protect European residents. So even though I'm American, I have an American passport, and even though I live I live for our purposes here in the EU or the UK,
yeah.
GDPR still protects me because I'm a resident here. So the answer to your question is GDPR applies to you as a company, no matter where you are based, if you are processing or otherwise using data that belongs to a European. And this is really important, especially with e-commerce, because if you're selling something online and let's say you're mainly focusing on like a t-shirt or something that's like for Miami, like Miami Dolphins t-shirt,
Yeah.
you're thinking, oh, only Americans are going to buy that, but that's not the case, right? So you really need to be aware of the different laws that might apply to you regardless of where you're based.
That's really helpful, Kelsey. One point again, I think you already mentioned it earlier when you were talking about the CCPA, but just because you're compliant with one doesn't mean you're compliant with the other. There are kind of different nuances to both. So, thinking that, but if I'm compliant with the GDPR, then I'll obviously be compliant with everything else under the sun.
Yeah, and importantly too, I think this is really important to know is if a law doesn't apply to you, you might not want to necessarily go the extra mile. So some people think, oh, well, I want to, add in all of these various protections because I don't want to get caught out by the regulator. But as Alistair knows, especially sometimes if you try to go above and beyond, you're limiting your exposure to prospective clients. You might be deterring them from interacting with your website in certain ways. So it's really important to make sure that you have a good lawyer who will understand this and can explain it to you, or otherwise just do your research on how things apply to you.
Yeah, that's great. Thanks for those points. So in terms of CCPA and GDPR, is there more legislation coming down the road which we need to worry about, or do you think that it's just an ever-changing landscape?
Kelsey, you're about to say something.
Sure. No, I was going to say GDPR is massive. It's very, very long. The CCPA is about 12 pages long, and most of that is just fluff. So to answer your question, yes, I absolutely expect there to be more legislation stateside. With respect to the European ecosystem online, the GDPR should be in settled form now for the next couple of years. What I would personally expect to see is more specific legislation being brought in to address things like direct marketing, things like manipulated videos and whether or not that stuff's okay to have, things like online payments, cookies. So there are very different discrete things that will pop up, I think, from time to time. And for those of you who put content online, which would probably be all of you, right? We're going to be seeing a lot of changes to European copyright law as well.
I'll just add 2 points to that, if I may. Brexit, sorry to say that word.
Yeah, I
Um,
wondered.
but yeah, Brexit, which is apparently the transition is ending in December. Who knows, whether we can trust what they say these days. But that, obviously we've left the EU, but we're in the transition phase of still being part of the EEA, which is important for data protection purposes. After the 31st of December, we will no longer be in the EEA. I don't think we know yet, Kelsey might correct me on this, but I don't think we know yet how, after that point, the UK is going to be treated for the purposes of data transfers.
All right.
So
That's right.
after the 31st of December, if you're a UK business sending data out of the UK to another country, you may need to think about introducing additional safeguards to protect that, which brings me on to my second point, which is that people listening may or may not have come across the term privacy shield, which was the safeguard used to transfer personal data from the UK to the US,
Yeah.
which sadly has just been blown out of the water by.
Exactly. You guys might
Yeah.
remember me saying that the US doesn't really have a comprehensive privacy law, and they have a lot of interesting things going on with national security and wiretapping. So the EU was basically like, oh my gosh, let's not send Kelsey and Alistair's data to the US because it might be spied upon. And so the shield was like this protective layer as data
So
went
we
in and
thought.
out of the US.
Yeah, so I mean, the short answer, the point there is that's now no longer a valid form of sending personal data from the UK to the US, irrespective of Brexit. It's a separate issue. So lawyers and businesses alike who are kind of processing lots of personal data are at the moment scurrying around trying to work out how to resolve that issue.
Yeah.
No one's quite sure how to resolve that at the moment. It's a very, very much a moving feast. But again, if you're sending data to the US in that way, it's probably worth reading up on that and being aware of that.
Joel, if you don't mind, I'd like to ask Alistair a question that I actually came across
Oh,
just
God.
the other day. Is that okay?
I mean, I can't promise I'll answer it.
This is
But
getting
I'll
good. Come
try.
on, guys.
So basically, I know someone who's developing a website, and they're really into football, American football. And what this person wanted to do was post a iframe containing a link to another person's social media account. So we have our website, we have our WordPress, right? Inside is the Instagram, like the dynamic iframe. But that picture is representing something that infringes someone else's copyright. The NFL, which is the American Football Association, they always get really freaked out when people like post clips and videos from their games. So if I'm a website designer and I post content that's not really mine, but I'm sharing it, but that content infringes on someone else's copyright, am I going to get in trouble?
Blimey, that's a good question. I guess the NFL, if they were so minded, could probably go after either party. They could go after the person in the middle who's shared that initially, or you who's then framed that on their website. I suppose what I would say is that's where having clear terms and conditions on your site around liability for content posted or kind of content uploaded is really important. I guess in the context of framing, that is where ideally, I know it's not always easy, but in an ideal world, permissions for anything put on the site will be obtained. So that's what I'd say there. Kelsey, I don't know if your screen has frozen, your picture's frozen. I don't know if that's happened for Joel as well.
I think we're okay.
It might be your deep fake, Kelsey.
It might be my deepfake. Well, I'm very pleased to have received your answer because that's exactly what I told the person who was doing this.
You.
It happened to be my husband. So.
Oh, right. Okay, good.
So I'm interested in one thing. Have we seen any major cases in terms of GDPR and CCPA Has there been anybody had it for infringement of it, or is this likely to happen? What do you
I
think?
can answer the CCPA bit very quickly.
Yeah.
Go for
And
it.
it only entered into force in
Right.
July.
Oh.
And so we haven't seen a lot of action. Interestingly, under the GDPR, an individual, so every Kelsey or Alistair on the street, can bring a complaint to the ICO or the supervisory regulatory body, which Alistair mentioned. In California, it's the attorney general, so like their lead prosecutor for the state, that actually has to bring an action against the naughty company. So haven't seen anything out of California just yet.
Okay.
Yeah, and I suppose just quickly on the GDPR front, there have been fines. I think initially, kind of in mid to late 2018 and 2019, they weren't actually as high as people were expecting. Kelsey may be able to remind me which of the kind of the mega tech companies was hit, but I think the approach from the ICO is very much to make examples of these trillion-dollar companies as opposed to going after the SME type companies, although that doesn't necessarily mean that you shouldn't do your homework. I think it was Facebook that got slapped with a very large fine, and probably others.
Yeah, and Alistair makes a really good point here. At the end of the day, regulators are people too. Just like lawyers are people too. We're all kind of learning and growing and kind of figuring out how these new and very important laws that regulate the ecosystem online actually work in practice. So by and large, although it's not at all accurate to say that, oh, you can just do whatever you want and no regulator will come after you, it is important to remember that we're all still kind of figuring it out as we go. And for that reason, regulators have a tendency to focus on the big fish in the sea rather than the small entrepreneur or someone who's just starting out.
Yeah.
Well, that makes sense. But I think we can all agree that the direction of travel is very much to this controlled cookie kind of environment where people understand how the data is being used. So
absolutely, especially as more and more millennials and Zoomers kind of enter into like the actual dynamic economy. It's no longer right to say, oh, well, I never used a computer before. Everyone knows, everyone's online, everyone's on social media. There will no longer be an excuse for just not caring about these very important laws and regulations, as well as the contracts that Alistair mentioned at the beginning of the presentation.
yeah, that's good. Well, we had one final question, and that was somebody picked up on what you mentioned earlier, Alistair, about the cookie wall, where you can't get into the website because it presents something, and they thought they were doing a good thing with that, but apparently it sounded from your description that wasn't actual consent.
So yeah, it's a nuanced point. If what you're presenting says effectively in might be these words or might be different words,
Yeah.
you can't access this site unless you click here, then that isn't freely given consent. What is, and what I've seen actually recently sites doing, is that pop-up appears and it stays there, and kind of in the interim period before the user clicks accept, cookies haven't been set.
Yeah.
But it's popping up. It's not saying you can't continue to use the site unless you click accept. It's appearing and remaining there, so it's prominent and that information is being kind of brought to the user's attention. But they can still use the site, but it's kind of there at the side. If the cookie wall is, as I say, if it's literally saying,
Yeah.
in order to continue to use this site, click here to accept cookies, then that is where you get into a bit of hot water. So yeah, it might be worth softening that approach slightly if that's what you're currently doing.
Yeah, okay, that's fair. It's very interesting. I think there's going to be some interesting landscapes with how you soften that approach, because I've seen some companies sort of saying, look, if you accept these things, then we'll offer you some free content or something along those lines. Because I mean, like, there's one of our clients in the States. He specializes in Facebook advertising. Well, of course, you may well have heard of the Facebook Pixel. Well, if he's not running the Facebook Pixel for people, or if that's behind a consent banner, that can cause problems. So I think it'd be interesting to see if the consent banner can evolve at all to get a bit more enticement and offers in there, as long as people are clear what they're signing up for, I think.
Yeah, I guess my devil's advocate point there would be the consent has to be freely given. So I don't actually know what the regulator's attitude would be if the individual is kind of effectively being incentivized to be for cookies to be set on their equipment. It's a very interesting point though. But you're right. I think going forward, hopefully, we will see websites kind of providing this information and obtaining consent in a much more streamlined fashion. I don't know what that is yet, but there are hopefully lots of clever people out there who are able to do this or kind of move towards doing it in a way that is a lot less clunky, because it is clunky at the moment, and it does detract from the web experience. And that's where the balancing act comes in between individuals' rights, to privacy and to not have their personal data banded around, and technology and having a slick experience. So that's basically the clash that Kelsey and I are currently kind of towing that line, to be honest. Trying to advise.
I think technology certainly has got to step up this game, because I mean, we obviously develop websites and we come in, we've got to troubleshoot a lot, and I've seen many websites where there's a cookie banner saying consent, but it's not actually doing anything. It's not affecting any cookies, not stopping anything appearing, not appearing. And you get this, people install a plugin and they think, oh, that's right, we got consent, we got a little banner, but it's not actually doing anything,
It's just there for show.
Well, it's there because I think somebody thinks they've solved the problem. But of course, like you mentioned earlier, one method of doing it is to stop a certain cookie showing until that consent has been allowed. Well, if the banner isn't put in a programmatic manner, then it's just a bit of fluff. It doesn't do anything.
I will say I don't envy the web developers listening, because this is a tricky area, definitely.
Well, it's very tricky because of course we don't want to get involved in giving legal advice. So people come to us and say, what is GDPR compliance, which is why I want to speak to people like you guys to say that no, speak to DAC Beachcroft, and then we'll do any technical bits on the website, but they're the people to tell you, just to have that legal conversation with. Yeah.
Yes.
Good.
Cool.
Well, look, that's it. I think we've been online for an hour, and thanks very much for your time. I don't know if you can give us a copy of the slides, whatever. I can put onto the blog post, but we can have a chat about that later on. I hope the audio issues didn't cause anyone any problems out there, but failing that, we'll be back in 2 weeks' time with Steve Kirtley talking about the future of websites. So thank you very much, everybody.
Cool. Thanks, everyone.
Do a wave.
Thank you.
Yes, I have to do a wave at the end.